Welcome to KelleyDryeAdLaw Access podcast, and this is Simone Roach. Recently, the FTC's final negative option rule was published in the Federal Register, starting the clock on the effective dates for the agency's expansive overhaul of requirements related to goods or services sold through any negative option or automatic renewal plan, including free trials, subscriptions, and repeat delivery offers. And for an overview of the final rule, please see our previous post. Based on the publication date, the rule's blanket prohibition on deception will become effective on January 15, 2025, and the provisions related to the disclosure, consent, and cancellation of negative option features will be effective on May 14, 2025. Or will they? The rule is currently being challenged in multiple circuits, and the incoming Trump administration could either cut back or scrap the rule altogether. Recall that both Republican commissioners dissented to the final rule. Congress could also decide to do away with the rule under the Congressional Review Act, which allows Congress to nullify agency rules promulgated within a look-back period based on the number of days that Congress is in session. And for all these reasons, it is entirely within the realm of the possibility that the current rule does not ultimately take effect, or that only certain aspects take effect. And amidst this uncertainty, as businesses evaluate whether to overhaul or modify any of their subscription practices, it is important to keep in mind that even if the final rule is set aside, repealed, or significantly amended, there are still myriad state laws to consider. Significantly, as we previously reported, new amendments to California's already stringent Automatic Renewal Law, ARL, become effective on July 1, 2025, and mirror or even go beyond many requirements adopted under the FTC's rule. So what are the key new California ARL requirements that companies will need to comply with, regardless of the outcome of challenges to the FTC rule? Obtaining express affirmative consent to the automatic renewal terms beyond consent to an agreement containing the terms. A ban on including information that detracts from or interferes with the consumer's ability to provide affirmative consent. A ban on misrepresentations of material facts related to the underlying good or service. Disclosing additional specific material terms prior to obtaining billing information. Maintaining verification records of a consumer's affirmative consent for at least 3 years or 1 year after the contract is terminated, whichever period is longer. Allowing cancellation through the same method used to sign up or interact with the business without obstruction or delay, and imposing limitations on safe offers and specific requirements on offers made in different media. While companies operating in California will need to comply with the above requirements regardless of the fate of the FTC's rule, the FTC's rule imposes some unique issues and requirements, including the following: broad application to any negative option program in any media, including B2B transactions; unambiguous affirmative consent to the negative option feature separate from any other portion of the transaction; cancellation at least as easy as consent, that is, proportional consent and cancellation processes; ban on the use of a live or virtual representative, for example, chatbot, for cancellation if not used for consent. Some of these ostensible differences may end up being more academic than practical, particularly if California aggressively interprets certain requirements in its statutes. For instance, California may not interpret its consent and cancellation requirements much differently from the FTC's unambiguous affirmative consent or proportional cancellation requirements, even though its statute is less prescriptive. Where does that leave businesses? Unfortunately, with more uncertainty than answers. At the end of the day, companies will need to conduct a fact-specific risk assessment to determine how closely their practices align with the to-be-effective California requirements and pending rule requirements. And if you'd like more information on what you've heard on this topic, please contact either Donnelly McDowell, kwhite, Gonzalo Mon, or Beth Chun, and you can find their contact details in the show notes. And also, Please see our Advertising and Privacy Law Resource Center, available at KelleyDrye.com.